As a personal injury lawyer, I get questions all the time about California's law as to comparative negligence, also sometimes called comparative fault. What this means is that if you get injured by somebody, you can sue and recover money damages even if you are partly responsible for the accident. A classic example is where you roll through a stop sign and then get T-boned by a car that comes speeding through the intersection. At trial, the jury finds that you are 20% at fault for failing to come to a complete stop. But the jury also finds that the other driver is 80% at fault for speeding and not stopping at all for the stop sign. Let's say that your damages are $100,000. Because you are 20% at fault, your damage award will be reduced by 20%. You will collect only $80,000 rather than the full $100,000. It's important not to confuse the doctrine of comparative negligence with that of contributory negligence. Contributory negligence is a much harsher rule that says if you are partially to blame, even 1% to blame, then you are barred from recovering any damages. California used to follow the law of contributory negligence, but in 1975, the California Supreme Court ruled that it was unfair and replaced it with comparative negligence, the rule that we still follow here today. This is important because in many accident cases, neither party is 100% right or wrong. Comparative negligence allows the victim to recover damages so long as the other party is at least partially to blame. If you are an injury victim and you're looking to recover damages, even if you are partly to blame for causing the accident, call us here at Shouse Law Group. We've helped many accident victims in just that situation.